If we can't do anything else in our lives, the most thing that we can do is just be brutally honest with ourselves. Holly needed to be honest with herself and accept that. What was the reason that you felt that you need to go through it? Did you make promises to somebody? I mean, who were the people that were involved? It looks like some people was involved. It looks like some people needed it to happen more than she did. Why was this act such a desperate, it's got to happen at 9 o'clock this motherfucking morning act? Why? Does anybody know? What was the urgency? What was the urgency? Why did it have to go down that morning? At the end of the day, why the fuck we didn't get invited to the party? What the fuck was this about? And I'm not letting it go. What the fuck was this? What the fuck was, and I done already figured out who this possibly is. What the fuck this is? And everybody in the background, I don't want to show her little hashtag thing because her dumb, the aunt, her weird self is the one that snapped the photos, but one of our supporters screenshotted the snap and forgot that she had it and just sent it to me. But listen, everybody surrounding this chick, hold up. Everybody is in black. We did not get the fucking memo. Either somebody was celebrating the fact that she did a job, a terrible job, or she was celebrating the fact that she was already two months free at this time, which she's not free anymore because she actually got arrested. She was actually charged about 30 days later.
And what this says, and it was entered by the judge today, is the court having found that the people of the state of Illinois have duly requested that the defendant, and in this case, we know the defendant is Quadesia Holly Johnson, be produced for the purpose of taking buccal swab samples, which is your inner cheeks. They want DNA swabs from the inner cheeks. It is hereby ordered that the defendant shall be delivered to the custody of a Cook County investigator from the Cook County State's Attorney's Office for the purpose of taking buccal swab samples, and shall be returned to the custody of the Cook County Department of Corrections immediately after said buccal swab samples are obtained. So,
a defense attorney stands before a judge. Her client, accused of a brutal, point-blank murder, sits in custody, denied bond 3 separate times. The attorney's request isn't for a new bail hearing. It's not to suppress evidence. It's this: Your Honor, I need you to sign an order to place my client into protective custody. The judge, known for his no-nonsense approach, has one question: why? This moment, from the February 3rd, 2026 hearing in the case of Quadesia Holly Johnson, isn't about guilt or innocence. It's a window into a high-stakes legal chess match where every move is calculated, where a request for safety might really be a setup for an appeal, and where a defendant's own family might be handing the prosecution their winning argument. Before we break down this critical update, if you're fascinated by the legal strategies that unfold behind the headlines, make sure you're part of our community. Subscribe to True Crime Unraveled on YouTube and hit the bell. Follow True Crime Unraveled TV on Facebook and TikTok. We see every single comment you leave, and we read them all. Keep them coming. Since September 8th, 2025, the story of Romica Meeks has been one of relentless pursuit by her family for justice and by Holly Johnson's defense team for freedom. Holly has been denied pretrial release repeatedly. Judges have labeled her a clear danger, pointing to the brazen nature of the shooting near a school and the alleged fist bump with Carlos Smith afterward as signs of a cold consciousness, not panicked self-defense. The February 3rd hearing was meant to be a procedural step. Instead, defense attorney Ari Williams made 2 requests that reveal her long-game strategy. First, she asked Judge Clancy to sign an order placing Holly in protective custody within the jail, claiming the nature of the case and ongoing threats. The judge, sharp as a tack, immediately asked for the reasoning. In legal terms, this safekeeping order is unusual for a pretrial detainee. It isolates an inmate for 23 hours a day. The question everyone is asking is, why would Holly need that now? The intelligent deduction here is multifaceted. Genuine threats in a high-profile case are possible, but legally this move can also be strategic. By having Holly placed in a restrictive, isolated environment, the defense might later argue to an appellate court that her conditions constitute cruel and unusual punishment, especially given her pregnancy. It builds a narrative of a defendant being unfairly punished before a verdict. It's a potential foothold for a future appeal, suggesting the system is stacking the deck against her. Judge Clancy, after hearing the rationale, agreed to sign it. But in doing so, he made the defense articulate their reasoning on the record. The defense's second big request was for a thorough DNA analysis of the firearm. Specifically, they want their own expert to observe the testing. Simultaneously, the prosecution requested a court order to obtain Holly's DNA swab and to access records from the Department of Children and Family Services, or DCFS. The judge granted both sides their requests.
Our assignment desk based on everything that they gathered that happened in court today, based solely on documents that were presented. And so what I can tell you is that motions were filed, and all of those motions were regarding DNA testing. And in fact, we do know that Quadesia Holly Johnson will be back in a courtroom on March 3rd of 2026 at 9 in the morning. And let's get into what was filed. Some of the dates and stuff are cut off on this because I printed it as pictures so I can see it really big. But let's get into what was filed. So this was filed on today. So today is the 3rd. Is that accurate that today is the 3rd? If today is the 3rd, hopefully that's right, because I can't keep up with all the days. Sunday, Monday, Tuesday. Yeah, today's the 3rd. So this was filed today. And what this says, and it was entered by the judge today, is the court having found that the people of the state of Illinois have duly requested that the defendant, and in this case, we know the defendant is Quadesia Holly Johnson, be produced for the purpose of taking buccal swab samples, which is your inner cheeks. They want DNA swabs from the inner cheeks. It is hereby ordered that the defendant shall be delivered to the custody of a Cook County investigator from the Cook County State's Attorney's Office for the purpose of taking buccal swab samples, and shall be returned to the custody of the Cook County Department of Corrections immediately after said buccal swab samples are obtained. So that's one document. All of these documents are kind of like the same, but some of them give you a little more detail. Again, I'm just giving you what the documents say. Again, this is not for me. This is straight from the documents, and I just want to be clear on that. So this is this says motion for buccal swab samples, and I'm just reading it straight from the paper, so there's no confusion here. Now come the people of the state of Illinois by their attorney, which is the Cook County State's Attorney, Eileen O'Neill Burke, State's Attorney for Cook County, Illinois, Assistant State's Attorney, and move blah 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 this honorable court to order the defendant to submit to the taking of buccal swab samples, and then they cite a rule. And in this case, it's the Supreme Court Rule 413, parentheses A7. In support of this motion, the people state, number 1, defendant Quadesia Johnson is charged in the above captioned matter with the offense of first-degree murder. Number 2, the firearm involved in this matter was swabbed for biological material. These swabs will be submitted to the Illinois State Police Crime Laboratory for DNA analysis. So they're trying to see whose DNA is on the weapon. Is it solely Quadesia Holly Johnson? Is it someone else's DNA also on that weapon? And so they're trying to get to the root of that. Whose DNA was on the weapon? A buccal swab from the defendant is necessary to conduct further DNA testing. So that's the inner cheeks. So if you ever, I'm sure you've seen it, people talk about, having inner cheek tissue. That's this. That's all of that. Just so we're clear on what that is. Like in my case, I have big cheeks, so I have a lot of buccal fat in my cheeks. So buccal is inside the mouth on the cheeks. That's where they swab for DNA. Same thing, like, for example, if you were going to swab for DNA testing for a child to prove if a person is the parent or not, father or not, type of thing. So I want to read that third point again. A buccal swab from the defendant is necessary to conduct further DNA testing, and then it goes on to be signed by the assistant state's attorney. And then it ends with saying, wherefore the people respectfully request this honorable court to order defendant Quadesia Johnson to submit to said buccal swab to be taken by an investigator of the Cook County State's Attorney's Office, which is really the initial document in part that I read, the very first one or technically the second one that I read. And then here's another one. So this is the notice of consumption of DNA evidence. Now come the people of the state of Illinois by their attorney, Eileen O'Neill Burke, same language, state's attorney of Cook County, and then it goes into James Constantopoulos, who is the assistant state's attorney. I think it's Constantopoulos, if I'm not mistaken. I think that's how you say it. And advise the defendant as follows. Number one, the people have been notified by the Illinois State Police Division of Forensic Services that it may be necessary to consume the biological material contained in recovered evidence related to this case in order to obtain optimal results in DNA analysis. And then number two, the people will be given the Illinois State Police permission to consume evidence as necessary to complete DNA testing for the following items submitted under CPDRD, and then they're listing the RD is usually the police report information, marked with ISP lab case number, and then they give that inventory number. And so they're asking for swabs from a firearm containing the suspect's biological material. So those are the documents that came out as a result of court today. So they're looking for DNA evidence. Exactly what they're on the hunt for in terms of the evidence, I don't know. It's safe to say that it's DNA evidence that they're looking for. And they're specifically looking at Quadesia Holly Johnson's DNA. They could be trying to see if there's other DNA that will be found as well. So that's where we are. I don't want to make any assumptions, but that's typically how it works. And so that's typically what they do in a case like this. They look to see whose DNA is where. And so that is what they're doing at this time. And I'm sure that DNA evidence should be back by the next court date, which again is March 3rd of 2026. So I'm sure this actual evidence will be presented. It will come up in court. And so we will have an update then. I appreciate
Let's unpack this. The defense wanting DNA analysis isn't about finding an unknown killer. They know Holly fired the gun. This is about the how. They're likely looking for any minute evidence, a partial print transfer DNA that could support a struggle, that could bolster the claim that the gun was grabbed or that Holly was in a physical altercation. They're leaving no stone unturned. The prosecution's move for DCFS records is particularly telling. It suggests they are investigating the environment around Holly's children. Remember, Holly's infant was in the car during the shooting. The state may be looking into prior reports, perhaps even the false allegations Holly previously made against Romica regarding her son. This paints a broader picture of character and pattern. Attorney Ari Williams's core strategy remains firmly planted in self-defense. She leans heavily on two pillars: Holly's valid concealed carry license, or CCL, and the 911 call made during the confrontation. But let's be clear about what these things mean in an Illinois courtroom. A CCL is a license to possess and carry a firearm. It is not a license to use it. It is not an immunity card. The law is strict. Deadly force is only justified if a person reasonably believes it's necessary to prevent imminent death. Shooting an unarmed person in the face multiple times automatically places that claim under a microscope. The defense's emphasis on the CCL is a strategic play for perception. It's meant to suggest responsibility and lawfulness to a future jury, to separate Holly from the image of a common criminal. The 911 call is similarly tactical. A caller in panic can sound convincing, but a 911 call is a self-reported story. Its value crumbles if forensic evidence, witness statements, and the autopsy tell a different tale. The prosecution will argue the evidence does just that, showing a pause between shots, a retrieval of the firearm, and a victim who was physically restrained by Carlos Smith at the moment she was killed. To understand why Holly remains in jail, look at the judge's previous reasoning for denying bail. It was a three-pronged test, and the state met every single point. Prong 1. The proof is strong. The judge found the evidence convincing and specifically noted the pause between shots, suggesting time to think, not a reflex. Prong 2. Real and present danger. The judge stated Holly is an ongoing threat. The act happened in public, near a school, in daylight, with witnesses present, showing a blatant disregard for public safety. Prong 3. No conditions can make it safe. This was the strongest language. The judge stated that no ankle monitor, no house arrest, no condition would reduce the risk. The court had no faith she would comply. The bottom line? The court's assessment is about cold, hard risk. The evidence is strong, the danger is ongoing, and no supervised release can guarantee community safety. Now, let's talk about the picture. On November 8, 2025, a month after Romica was killed, and while the community was wearing pink in her memory, a photo surfaced from Holly's and Snapchat. It shows Holly at what looks like a pool hall party, surrounded by men. She's beaming, wearing head-to-toe pink. Only one other person in the shot is in pink. The question is glaring. What was being celebrated? Was it a premature victory lap? A gathering of supporters convinced she would never be charged? The timing and the specific color choice feel like a direct, taunting contradiction to the public mourning for Romica. For the prosecution, this photo isn't just in poor taste, it's potential evidence of a lack of remorse. For followers of the case, it deepens the mystery. Who are these people? What narrative were they building amongst themselves? This single image fuels the public's perception that the full story, the motivations, and the network involved run deeper than what's been presented in court. So, where does this leave us as we look toward the next court date on March 3, 2026? The discovery process is ongoing, with both sides arming themselves with DNA evidence and personal records. Holly Johnson is in protective custody, a move that could be about safety or could be the first move in a complicated appellate strategy. Her defense is preparing to argue she was a licensed carrier forced into a split-second decision, while simultaneously laying groundwork to shift blame and highlight procedural pressures. The questions for us are strategic and human. Is the request for protective custody a legitimate safeguard or a legal Trojan horse? Does the November party photo reveal a community that never believed accountability would come? And with the defense's strategy so clearly mapped, can the prosecution's physical and witness evidence overwhelm the narrative being built? We want to hear what you think. Does this legal maneuvering change your view of the case's direction? What's your theory about the November photo? The comment section is for you. If this deep dive into the legal trenches of a developing murder case captivated you, please show your support. Give this video a thumbs up, subscribe to True Crime Unraveled on YouTube, and follow us on social media. Your engagement is what allows us to keep unraveling these complex stories. Thank you for watching. We see your comments. We value this community. For Romica, for the truth, and for a justice system where strategy meets evidence. We'll see you in the next update.
So, this is... Okay, I'm going to share some information that I already had that I wanted to share. But I want to make sure that everybody knows that I still feel like they're up to stuff. You know, that defense is something else. That's all I got to say. That defense... They be a trip. So did y'all hear? I'm not trying to say anything negative about anybody. Yes, thank you for the pink hearts. Keep giving them. And if anybody happens to pop on here and they're a part of the Justice for Joe campaign, throw some blue hearts and let me know that you made it here as well. But y'all know good in time well that she popped a little bit of an attitude with the judge. And I loved it because this judge is like, you can tell by a lot of his cases, because I was listening to all the cases before the Quadesia Johnson case. This guy got this law like memorized. Like, you cannot, this dude is smart. Okay. Some of that stuff is memorized. It's here. It's here. Okay. You can tell. I like Judge Clancy. I do. I feel like he means business. And thank you for everyone who was in support of Dro as well. We had a beautiful queen whose life was taken. We had a handsome king, smart, whose life was taken. So yeah, we want to stand up for these people. We want to let people know, hey, we need justice for these individuals. They were innocent, they were unarmed, and they surely weren't ready to lose their lives, right? So back to Judge Clancy. That man is something serious. This guy knows his stuff. He is a very respected judge. I bet he was a beast of attorney in his day. I would like to research that. But you can tell that this judge is really dedicated to adhering to the laws. This man is smart, okay? So, did you notice that when the attorney said, when we can't record anything or anything, so let me see if I put it in my notes, because I took notes. Okay. I didn't put it in my notes specific, but I'm gonna go off of memory, okay? So basically the judge is like, she's like, Your Honor, I would need to get his signature on putting her in protective custody. And the judge said, why? In so many words, right? And to me, like, that was like the golden question, because to me, and sidebar, okay, going back to that photo that I found in September, Miss Big Bad got the drink up and, you partying and shit, and then you got all these dudes surrounding you and looks like y'all celebrating some shit. Like, what? We didn't get the memo. We didn't get the memo. We wasn't invited to the party. I wonder why. Yeah, I wonder why. So my thoughts is like, oh, you want to have protective custody? I'm with the judge. Why? So Attorney Williams did a little snap, and she was like, well, Your Honor, it's because of the nature of the case. And that's just her vibe. That's what her vibe was. That's what the vibe was. So what I got from it was Attorney Williams basically saying, hey, I tried to get Cook County to sign off on this or to put her in protective custody, and they said that we need a judge's signature. So the judge, whatever she needed, she didn't have it. She wasn't prepared. So she had to tell the judge that she was going to draw it up real quick. The judge agreed that he was going to go on ahead and sign the document for her to go into PC. Okay. But at the end of the day, hold up. Let's go. Okay. So, this would be an order granting protective custody, a safekeeping order. Okay. Because somebody doesn't feel so safe. Okay. So this is the actual document that the judge signs directing the jail or sheriff to place the inmate in protective custody. That's what was requested by Attorney Williams. And Attorney Williams did not have the motion prepared. I would like the attorney to tighten up, because she's just not doing so good on some of these things. And nobody's perfect, but she's got to tighten up. You can't ask the judge to sign something that you didn't properly give, and then you're saying, oh, I'm going to do it right now. Hey, I'm not trying to talk shit about nobody. I'm just saying she needs to tighten up. You know, she's probably having too many late nights, having a good time, doing too much. She's got to buckle down and get this stuff going. Okay. So it's typically issued after a motion or request is filed. So the judge pretty much said, hey, Terry. The judge pretty much said, he asked why. Her reasoning behind it was, this is a very serious case. She pretty much asked Cook County, they wouldn't do it. And the ongoing threats. Okay, so everybody. Let me see what Reese said. If this was my attorney, I would fire her, because when they put Holly in protective custody, there's no reason to ask for bail. Exactly. But let me tell you what I'm thinking. I'm going to tell you what I'm thinking. And, you know, this is just us sharing our thoughts, okay? We're not attorneys or anything like that. We're just talking. You know, we're on the phone, we're talking, and we're having a good time. So basically, what I believe is... I believe that they could try to use this possibly, and I mean, this is not factually, that they could possibly use this reason with the appellate court. Building a narrative that Holly was acting in self-defense, one. Putting her client in protective custody to prevent something, because she's basically saying, hey, my client only... What was that noise? My client only acted in... Hold up. Oh, it's my laptop, sorry. My client only acted in self-defense. So since my client only acted in self-defense, boom, she should be released. And now we need protective care. We got to do all this extracurricular stuff. My client shouldn't even be here in the first place. Truly, yes, she should be there. Truly, yes. Nobody missed a beat on what was needed for this defendant. Okay? Nobody needed to change anything. All of the judges that sat down with this case all agreed that she was a danger, she was a risk. We still feel that way. We're seeing more and more and more information that shows this girl was just toxic. This girl was just trying to set up the stage and thinking that, hey, I'm going to get away with this because I did this and I did this. No. Even if you have a CCL, even if you feel that you're acting in self-defense, okay, you can't just take your firearm and go crazy with it, okay? You have to take in regards to the time of day it is, okay? We're in a school zone. There's teachers, there's children going to and fro, people getting on the bus, going to work, going back and forth. Life is moving. How do we feel that we need to take a life before 10 a.m.? Okay. It's just too much of a mess. Okay. I just don't see it being better any other way than the way that the judges decided that they needed to do it. And I commend Attorney Williams, for working so hard. But her client, possibly shouldn't have worked so hard to put herself in the vicinity of Romica Blackman. And then maybe we wouldn't have this situation. She would be free, pregnant, tending to her toddler. Romica would be tending to her school-age child. Carlos would be somewhere running around doing what he do. And we would be minding our own damn business. But we can't mind our own damn business because Romica was murdered. And we are waiting and we are sitting and we want justice, right? So yeah, we're not going to move. So let's carry on. Let's talk a little bit more about this filing. Okay. So basically, Ari said at court, they told me that they wouldn't grant this without a judge signature. Okay. She was a little bit all over the place, but she cleaned it up, pulled it back together, whatever. I know y'all noticed it. Cause see, y'all smart out here in these streets. Okay. So basically, this is a motion that asks the court to intervene due to a credible safety threat. Now, I wasn't truly convinced, but I can't say anything. We don't know what Holly could have tangled herself up in. We don't know if she's gang affiliated and she's done pissed the gangs off because she done got the gangs in more of drama than what they were before Romica even died. They should have just left Romica alone, because now that y'all done took Romica's life, y'all in more deep shit than what y'all was than when she was here. Tell me where I'm wrong. The only thing that this death has done was opened up a full fucking can of worms. Romica should have been left the hell alone. Okay? We don't know where these threats could be coming from. We don't know if these threats are real. We don't know if there's somebody in the jail that wants to do whatever have you to Holly. I mean, we don't know. But I guess it is best for the attorney to act in behalf of her client. She was paid a whole lot of money. So yeah, protect your client, do right by your client, but come with the documents and do it the proper way. You know, people got to tighten up. When it comes to the law and when it comes to these courtrooms, we got to be on point. Okay? This stuff has been sloppy on the defensive side ever since they stepped into the playing field. If I'm wrong, tell me that I'm wrong. Tell me that I'm wrong. If I'm wrong, say, Nina, you're wrong. Say, Nina, you're wrong. And if I'm really wrong, say, Nina, you're fucking wrong. But y'all know that I'm right. They've been a mess ever since. Their motions, everything that they've done, it's just been a mess. And I get it, because you have no way to win up against God. It's done. Okay? A beautiful, precious life was taken. It's too late. The damage is done. Now Jehovah got to step in. And now the angels got to step in. Everybody got to play their role. We got to play our role. And we got to keep our support active. Okay? So shout out to Attorney Williams for putting extra protection on her client, whether we agree with it or not. Because you was just Big Billy Badass when you even shot her in the face. You was just Big Billy Badass while you was all over the internet talking shit. But you need extra protection now. You was just the baddest bitch and been that girl, according to your bestie. You was just top shit while you was at the pool room with those dudes in November, while y'all was toasting up like it was a celebration that we didn't get invited to. I didn't get no invite. Y'all didn't get no invite. We didn't get no invite, but she was top dollar shit. Hold on, let me go up in here, because y'all, Don't stop. Listen, if we can't do anything in our lives, okay. Ooh, another case calls, but I gotta stay focused. If we can't do anything else in our lives, the most thing that we can do is just be brutally honest with ourselves. Holly needed to be honest with herself and accept that. What was the reason that you felt that you need to go through it? Did you make promises to somebody? I mean, who were the people that were involved? It looks like some people was involved. It looks like some people needed it to happen more than she did. Why was this act such a desperate, it's gotta happen at 9 o'clock this motherfucking morning act? Why? Does anybody know? What was the urgency? What was the urgency? Why did it have to go down that morning? Why? So yeah, let me go back up here. Let me go slow because y'all know I got about 20,000 photos. Y'all, I got photos that I got screenshots and photos that I've never even shared with y'all because at the end of the day, why the fuck we didn't get invited to the party? What the fuck was this about? And I'm not letting it go. What the fuck was this? What the fuck was, and I done already figured out who this possibly is. What the fuck this is, and everybody in the background, I don't want to show her little hashtag thing, because her dumb, her weird self is the one that snapped the photos, but one of our supporters screenshotted the snap and forgot that she had it and just sent it to me. But listen, everybody surrounding this chick. Hold up. Everybody is in black. We did not get the fucking memo. Either somebody was celebrating the fact that she did a job, a terrible job, or she was celebrating the fact that she was already two months free at this time, which she's not free anymore because she actually got arrested. She was actually charged about 30 days later. And then like the fake part for me is like, why are you always trying to do everything that Romica does? Like, why? Why does she look at the way Romica always does stuff with her tongue all the time? Why? Why does she want to be like her so fucking bad? And then this is, she would have been pregnant around this time. Look, she's decked out in pink. Look at this dude right here. This dude got the pink on. I believe I know who this dude is. I'll tell y'all, but I'm not going to put it on the internet. I know who this person is right here. You might have your back, baby, but Nina can't be fooled, baby. Nina can't be fooled, baby. You can think you can fool Nina, but Nina can't be fooled. You better ask. Nina can't be fooled. So yeah, why the fuck we didn't get invited to the celebration? Because somebody was celebrating something, but guess what? That smile turned into a frown when she was arrested. Not even 30 days later after this. Not even 30 days later. Okay? Nope. If you say who it is, I'll say yes, but y'all didn't say. But yeah, I this person, yeah. This person know who he is, but I know who he is too. I'm not going to share, but yeah, I know who that is. So y'all thought y'all was cute. Somebody said it. Antoinette, you're getting hot, girl. Antoinette, it wasn't Carlos. I didn't see Carlos anywhere in the photo. I didn't see Carlos anywhere in the photo. Antoinette is hot. It wasn't David. Remember, David got dreads, y'all. Come on, don't fall off now, y'all. David got dreads. Y'all don't see no dreads. Hot. Come on. Y'all just saying something. Antoinette. Don't say it, Antoinette. Antoinette, message me. Message me. So why didn't y'all bring the real Pink Mafia to the event? I guess we didn't get to be a part of the celebration because y'all wasn't shit in the first place for doing that. So my thing is, whoever was a part of the crew that felt that they needed Romica to go, you opened up a can of worms. The shit has gotten ugly. The feds is involved. Shit's getting crazy. Y'all's done opened up a can of worms. It's not Q. It's not Q. Q was nowhere to be found. Remember, this is in November. That was in November. This is in November. Q wasn't there, y'all. Q wasn't there. Okay? But anyway, so yeah, they opened up a can of worms. Shit done got crazy and it's out of control. And I know they can't do nothing with it. Because if they couldn't get Holly out by now, I don't think they're going to be able to stop the feds from coming. They already involved. They're already watching and, you know, checking the naughty list and checking it twice. Yeah, y'all ass is done. Shouldn't have fucked with Meeks. Should have thought about that. Okay, so let's talk a little bit more about this motion that was a few moments late, that wasn't technically filed in front of the judge, but the judge was nice enough to say, hey, I'll give the chick some protection. Forget it. If that's the only way that you'll get the protection, if you feel that your client needs this protection, cool. Get it ready. I'll sign it. Okay. So courts rely on sheriff duty care, Eighth Amendment to deliberate indifference to safety, due process pretrial detainees, state statutes granting court authority over inmate placement. Okay, so not Bisco. You're getting warm. You're getting warm, okay? But that's not him. So basically, at this point, the attorney has a duty to do, and she has to make sure that her client is safe because there's been some threats, supposedly. Myself, I'm thinking naturally that maybe they think that this will assist in the appellate court motion to try to overturn this pretrial detention that has not worked, has not budged, anything. You guys ask me questions. Ask me questions so that I can answer. Let's talk about a little bit of the information. Oh, we can talk about a little bit of stuff. I can't be on that long because she ain't getting out. She about to record. And then who wants to go in 23-hour lockdown? Like, girl, you don't want to all that talk. And she, remember our follower? Well, throw a party. Well, Tangela says, well, throw a party while you were in jail. You were sitting in the holding station. You were a hater of Romica. So shooting her in the face, and the other dummy thought y'all had it all planned out and it backfired. And he's out walking these streets without you. Make it make sense. Exactly. Like, is this crazy work? This all crazy work. Okay. So the prosecution also was told that DCFS was involved. So the prosecution want them DCFS records. Okay, none of that got sealed. See, this all makes sense. Everybody, let's sit down and let's think about this. Okay, let's think about this. Okay, Let me get a little bit of my ice, because y'all know I have a problem and I love ice. Okay. Let's think about this. So, the last motions that Attorney Williams attempted to file, she was trying to seal records. It was denied. Now, the prosecution is like, yo, we want the DCFS records. How many people was feeling like she needed to have charges in connection to leaving the baby in the car? Raise your hand. Raise your hand or throw one pink heart if you feel that she needed some charges in reference to leaving that baby in the car while she went and took a life. One hand up or a pink heart, right? Yes, 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 yes. We felt as if though she needed to be in trouble for leaving that baby unattended while she went to go do bad things. She walked back and forth in front of that baby multiple times. She had multiple times to make a better choice. But she didn't want to make a better choice. She wanted to do some toxic stuff. So the prosecution is all over it. And the prosecution is saying, hey, judge, we need to request the DCFS records. Now, another thing that they will find in the DCFS records is that, remember, Holly did some toxic stuff. And she actually made a report on Romica Blackman about her child that actually led to a lot of the tension between the two of them. You remember that? How dare you contact DCFS and tell somebody that somebody's child has warts or something weird and toxic, coming up with stuff and creating lies. That girl was out of control. But anyway, let's keep it going. So, the defense wants to request DNA off of the firearm. The prosecution wants to get evidence from the gun casings and stuff like that in relation to the gun. Right? So you remember. Okay, everybody remember when she tried to do the toxic stuff. So that may come up in the DCFS records because it concerns baby Amir and it concerns baby Cars. So baby Amir is Romica's child, and then Carson is Holly's child. But the difference is that Holly is free. Holly is alive and she's incarcerated. Romica was murdered. Okay. That was a wicked thing that took place. Yeah. I'm not sure. I don't know the details about where Holly's child is. Will I be evil if I said I didn't really give it him? I mean, the child has to be safe. I know the child is safe. My biggest concerns are Amir because his mother is not here. I like your thoughts. Yeah, and then getting pregnant in the middle of an open investigation. Then trying to use that as a reason to get released. Like the toxicity, it just goes on and freaking on. So, the prosecution also wants to swab Holly because they're trying to connect the so basically the judge had to agree to the swab of Holly and the DCFS had to be agreed by the judge. The judge said, cool, let everything go. Everything's ordered. Okay. The prosecution wants a expert to observe the DNA in reference to the firearm. If you want to send Amir something, I can send you the Cash App or the Zelle of Miss Tina. And they also have a P.O. box where you can send him things. And I will get that for you if you need it and if you don't get to it. Okay? All right. So another thing is, so the prosecution has a lot more evidence. So what we talked about earlier is that, it's time. Yes. So they have a Zelle in Miss Tina's name. They have a Cash App in Miss Tina's name. And they also had a P.O. box. I believe they still have the P.O. box. So we'll make sure that you guys can get everything. And guys, I would like to get a group together to make donations to Amir. And I would like to get a group together to make donations to Dro's children. Okay. I don't know if they actually did it. I'm not sure, but I remember the defense saying something about she wants a professional or something, okay? Yeah. I mean, and it's like, we know the child is safe. Like, he's not our responsibility. We have to be worried about Amir. Amir, his mother is not here no more. So yeah, the baby is good. Amir is the one, and even though, let's put it like this, okay? Because y'all know I'm not heartless, okay? Holly made a choice to remove herself from her child, right? She made a choice to remove herself from her child. Romica didn't have a choice. And that's what everybody needs to really think about. Romica didn't have a choice. Her life was taken in broad freaking daylight before 10 a.m. Okay? So, yes, our concern is going to be with Amir because he is suffering in a different way. Okay? Holly made a choice. Whatever suffering that her child has to endure, Holly and Carlos made a choice. Both of those parents were out there. Okay? She made a choice. You knew that there was a possibility that your ass was going to go to jail. So since you knew and you thought you was big hot shit and you was all cute in the pink and shit, now you're going to pay those consequences. And it doesn't seem like Attorney Williams is going to be able to pull a rabbit out of her hat to get her pretrial. But she's trying like hell, I tell you that. I tell you that. So like I said before, the judge wanted to know why she wanted protective custody. We figured that out. The next court is going to be for March 3rd, and it's going to be about discovery in person. So everything that the state got, everything that the defense got is going to be brought back before court to discuss in person in front of this same judge in this same courtroom. Everybody that was attended, we would greatly appreciate it if you would go back again. March 3rd, 2026.